Hi, we're just going to give you a quick and dirty overview of the last legislative session, some child welfare and juvenile justice bills we were following. Legislature's in recess right now. They will start again in January. So I'll be at home with a new baby, listening, watching on NET. So hopefully the baby is soothed by Ernie Chambers' filibusters. But anyway, the big one on the juvenile justice side was LB 464, the cleanup bill to last session's LB 561. Four major parts of that: expanded original jurisdiction for juvenile courts, had some of the cleanup provisions from 561, changed some of the truancy referral procedures, and then, as we talked about this morning, expanded the use of facilitated group conferencing in both child welfare and juvenile justice cases, and added some data reporting requirements for the administrative office of the courts. Basically, for the original jurisdiction, for cases, for any case involving a youth under the age of 14, the case must be originated and heard in juvenile court. So that is that part. And then with misdemeanors, all cases involving youth who are under the age of 18 at the time of the alleged offense must be filed originally in juvenile court. For youth who are 16 or 17 at the time of the alleged offense, the county attorney can motion to transfer that case to adult court. Same thing with felonies. If it was a Class 3A or a Class 4 felony, the case must originate in juvenile court, but again, the county attorney can request a motion to transfer that to adult court. For all the higher level felonies, the prosecutor retains the discretion on whether to file an adult court or a juvenile court, but the youth retains the right to motion a case from adult court to juvenile court if it was started in adult court. So as far as the cleanup, it added some language that was necessary for HHS and probation to contract to draw down the Title 4E funds. Needed some magic language in there that gave probation placement and care of juveniles, and so that just opened the door to more negotiations to draw down those 4E funds. Also, Judge Gendler touched on the community-based aid, appropriated $5 million for counties to use, priorities being for diversion programs, detention alternatives, reentry programs. Monica went through that kind of flow sheet of the payment of services. They put all of the payment of services in one section to eliminate some of the confusion. But basically, all the pre-adjudication detention costs, detention alternatives for brand new cases are county responsibilities. If it is a youth who already has a probation case open and gets a new charge, probation will cover those pre-adjudication costs, as well as all the post-adjudication costs for children once they are placed on probation. OJS begins to pick up the bill the minute a judge orders them to OJS custody for placement at a youth rehabilitation and treatment center, and continues to take those costs until they are released from OJS custody. So that means OJS is responsible for the detention in the county, awaiting placement at the YRTC, and also transportation to the YRTC. Probation is now required to give copies of evaluations and predisposition investigations to the legal parties prior to the court hearings if it's going to be relied upon in court. Also, 561 required that evaluations be completed within 21 days, and the youth return to court within 21 days with that evaluation. That's been extended to 30 days, except in cases where the youth is detained. If the youth is detained, they still have 21 days to bring them to court. Also, it cleaned up the process that needs to be followed prior to a youth being committed to either Kearney or Geneva. The county attorney must file a motion for commitment to a YRTC and show by a preponderance of the evidence that they've exhausted all levels of care, and also it's a matter of immediate and necessary, urgent necessity to be placed at a YRTC. Also tweaked a little bit the re-entry process to the YRTC. Also put in there that if the parties stipulate to the re-entry plan, they can stipulate by motion, and that would make it so you don't need to have a formal hearing to start the re-entry plan once they return. The truancy provisions, when Brittany was given the case law summary and in re Samantha, she said, the Supreme Court said that the mandatory attendance laws and the truancy laws don't interact, and the legislature could change that if they wanted to. Well, they did. And so now the school's failure to document the remedial efforts done by the schools prior to referral to the county attorney is a defense in both the truancy cases and in the educational neglect. Also, most importantly, the magic 20 days that used to be a mandatory referral after 20 days is now permissive. They can refer after 20 days, and also any absences that are due to an illness that made attendance at school impossible or impracticable cannot be used in that 20-day tally. Basically, on the data side, the state court administrator is required to submit an annual report tracking youth that are involved at both the juvenile and adult side of the court process. And so they'll start tracking that in January, so the next report would be in January of 2016. And then also in the facilitated conferencing, the funding and management for all that, for all those group conferencing, the restorative justice, the 3A cases, now goes to the administrative office of the courts. And that's 464.
So I'm going to talk about the child welfare side of legislation this year, and actually compared to past years, this was fairly tame, but there were a few bills that I wanted to go over that do affect your practice. The main one I'm going to talk about is LB 908, and the focus on that was with guardianships codified into 43.13.12.01. And what it says, the language of it is, if the permanency plan for a child established does not recommend return of the child to his or her parent or be placed for adoption, the court may place the child in a guardianship if, and then these are the terms that it's a 3A case, that they're more than 6 months in that placement, that if the child is over 10, that he or she consents to the guardianship, and that the guardian is suitable, able to provide safe and permanent home, and has made a commitment to the child. Somebody asked me at one of the prior regional conferences, if the child doesn't consent, does that kind of end things for the guardianship? And I think reading under the statute now, it does mean that, if you don't get the consent of the child, that it's an and, not an or, and that child consent for kids over 10 is required. When the judge is entering the order for guardianship, yeah.
I have a question on that. Why the age 10? That seems pretty young to make a decision like that.
I don't know. We weren't involved in the legislation. Was anybody here involved in the legislation for LB 908? I don't know why they chose 10. I've seen 14 in other areas.
I did. I'll deal with kids 10 years old making a decision like that.
Yeah. Yeah.
Over 50 can have a hard time with 10 year old. I guess we assume someone else is fine out with adoption or raising.
Right. Yeah, I don't know, Vicky.
I know in like research areas, I think that, and what they're doing here is the child has to agree, so the child is not consenting. They just can't do it, the child is assenting.
Well, the statute does say consent, but I think, yeah, what you're talking about is it's essentially assenting.
It is an assent, and I think that often assent rules go down a lot lower than, I mean, ages go down a lot lower. And I think maybe with a guardianship, if the child does not want that person to be their parent, it doesn't sound like a good idea.
Yeah, the thought could have been that if the child doesn't want the guardianship, the likelihood of it lasting is probably less likely, and so it's good to make sure that they're getting the consent. But as far as the age 10, not sure. When the judge does enter the order, these are the things that the judge should have, that they shall grant the rights and duties, same rights and duties as biological adoptive parent would have, and then they can specify the frequency and nature of family time with both the parents and with the siblings, and that they must require that the guardian not return the child to the parent without prior approval of the court. Now, this is something, there's also some language in LB 908 that has to do with the reviews. And I know this has been an issue across the state with juvenile guardianships. It's kind of been across the board as to how courts are handling. Some courts have 6-month review hearings, some courts don't. But I think the language is pretty clear in 908 that there are no longer to be permanency review hearings, that the court does retain jurisdiction to modify or terminate the guardianship, but that they shall relieve HHS from being involved and should no longer have the review hearings. Other provisions of 908 was just basically codifying the case law that's been around for a long time on abandonment, the intentionally withholding from a child, parents' present care, love, protection, maintenance. Also in 908, there was just some additional specificity with extending the guardianships to 21 with allowing those subsidies, so that's language is in statute now. And then they also just changed language. I'm thinking because it was confusing in some of the terms in the statute, it referred to DHHS guardianship, and they changed it to DHHS legal custody and care. And then it also just outlined that it confirmed the child continues to have the right to inherit, that the parents may still be responsible for support, and parents can consent to adoption.
Kelly, back to that whole issue of review hearings.
Mm-hmm.
Can the court require guardianship reports? Can they, if we're going to retain jurisdiction over these cases, are we not to have any kind of review or at all?
Well, the language of the statute says shall continue permanency reviews and case reviews. So your question is,
Shall
can...
discontinue with what you have. So discontinue permanency reviews and case reviews.
Right. So so from the 3A case that there no longer shall be permanency reviews and case reviews,
It's my understanding that the judge can appoint the guardian ad litem to remain on the case and make an annual report to the judge.
So saying that, understanding that you can keep guardian ad litem on the case, do an annual report to the judge. It doesn't speak to retaining guardians ad litem. It talks about relieving HHS. So I think that's an open question. The language doesn't say hearing. It just says permanency reviews and case reviews. So I think that is fairly broad, that it's not just limited to hearings. Judge Porter.
If we do these guardianships in the juvenile court under this statute, is the guardian excused from all those reporting requirements under the county court guardianship?
My understanding is no. I don't. Judge Gendler, do you know anything further on that?
I think they had to do all those things.
Yeah, they don't. But the question was, do you have to do the reports like you do in county court for the guardianships? And the answer is no, but that may change because there's people looking at it. I do want to mention one other thing. There is a Supreme Court rule that says if a child is out of the home, the court has to review the case every 6 months. So that Supreme Court rule is in conflict with this statute. And Supreme Court rules say that Supreme Court rules take precedence over statutes. So we'll have to figure out where we go with that.
There also continues to be in certain areas, the confusion of the protocol of when you do the county guardianship, the probate guardianship versus juvenile guardianship. And I don't think this resolves that. It outlines a little bit more of juvenile guardianships, but you still have that too.
My question is, who helps that youngster out if, okay, this is my guardian, and maybe a year from now or a few months from now, things aren't working out, does someone oversee that? DHS is out of the picture, I take it. I mean, that's concerning. I can understand why, from the explanation, why I went down to 10 years old, but instead of representative.
Well, I can just tell you what we do. We put a clause in the order when we establish a juvenile code guardianship that they have to report back to the county attorney or the guardian ad litem if there's a disruption, and to the court. And I think other people do that too. So hopefully that occurs.
And I'm gathering there's nothing in the statutory changes about if somebody wants to resume their parental rights. There's the case law that
Right.
says that the guardian has to prove that the parent is unfit, or else the court has to give the kid back to them.
Right. No change in the unfitness with the case law. Right. So it leaves lots of questions in the areas of guardianship. And I think I'm trying to remember who. I know Voices for Children worked on this some, but yeah, I think if you have input for next session on, I think it's a difficult issue, guardianship, and I think with the case law that you have, it's not easily changeable just by statute. Do you have something you wanted to say? Oh.
The other issue is, by virtue of this statute, I'm not sure we can do juvenile code guardianships on other cases now, only on 3As. So that's something we may want to expand.
I just briefly, I know I'm out of time, but I wanted to mention quickly other legislation. HHS is here so they can talk about alternative response. 660 extended privatization in the Omaha metro area, saying that HHS may contract with a private agency to do a pilot project, and then it required that an evaluation of that be completed and submitted to the legislature by the end of this year. 853 did some cleanup on Bridge to Independence, and we're going to talk about that in a little bit. 974 provided that HHS comply with certain strategic planning and benchmarks and be submitting those plans. And then 1093 had to do with what we were talking about this morning, that move funding from HHS, Child and Family Services, over to the Administrative Office of the Courts for pre-hearing conference facilitation in child welfare cases. And that had been amended onto 464. Any final questions? Okay, thanks.